Good afternoon and welcome to today's webinar, which is an introduction to IP, and this one is on designs. This is one of a series that we're currently doing. If you look on our website, there was previously an introduction to patents, and upcoming, I think next week, we've got an introduction to trademarks. My name's Dave Paton. I'm a European design attorney. I've got 15 plus years experience in IP. I'm also a European and UK patent attorney. Giving the webinar today is also my colleague Greg Iceton. Greg, do you want to introduce yourself?
Yeah, sure. Thanks, Dave. So yeah, as Dave said, I'm Greg Iceton. I'm also a European design attorney and a European patent attorney and UK patent attorney. And I'm currently in the Munich office and have been here for 13 years.
Thanks, Greg. Yes, I mentioned I'm down in the southwest in Bristol. So on with the webinar. So just to give you an overview of what we will be talking about today. Initially, I'm just going to give you sort of an overview of where design protection fits with other intellectual property rights, and then talk about the basics of design protection. I'll then pass over to Greg, who's going to talk about the different types of design protection, as these can get quite complicated, and also a discussion of the future of design protection. And finally, I'm just going to give sort of some examples of obtaining design protection and then some key takeaways. So, the IP landscape. So, as you're probably aware, there are a number of different intellectual property rights. Some are more commonly known than others, and on the screen is just a variety of the intellectual property rights that are available. Some, such as patents, protect the functionality of a product. Trademarks protect branding, and designs, which we'll be talking about today, protect the appearance of a product. There's also some other IP rights that you're probably less familiar with, such as utility models, trade secrets, know-how. You don't need to worry about any of these. This is just to give you a flavour. As I mentioned, today we're going to be concentrating on two key areas, which are registered designs and unregistered designs. These sort of usually lumped together as design protection, and the difference between them is really what it says on the tin. Registered designs protect products, but you have to apply to obtain the protection, whereas unregistered rights subsist automatically when you launch, when you publicly disclose your product. Greg will be going into these in some more detail in a little while, so don't worry too much. As I mentioned, design rights protect the appearance of a product. There's different types of design protection, and the important thing to know is that design protection varies by jurisdiction, on a country by country basis, and also if you want to obtain design protection in a specific country, it's likely that you're going to have to apply to obtain the protection in that country. What can be protected is quite broad. Design protection is a very good IP right for obtaining protection, because what counts as the appearance of something varies massively, as does what counts as a product. So a couple of important things to note. Registered designs and unregistered design protection don't exist in isolation. So you can have both registered and unregistered design protection in a single product. Similarly, design protection doesn't exist in isolation. So if you if you have a product, you may obtain design protection for the appearance, but you may also be able to obtain patent protection for its functionality, as well as some trademark and copyright protection. A good example of this is, for example, the Coca-Cola bottle. You'll all recognize this. The appearance of it will have been protectable. I mean, it's outside of the design protection now because it's, I think, probably 80 plus years old. But the appearance of it is would have been protectable by design protection. But equally, you know, the logo or just the shape of the bottle, for example, as shown on the right, are equally protectable by trademark protection. There may be patent protection will have been available maybe on the manufacturing method of producing the bottle, as well as, you know, the functionality of how the cap, for example, connects to the bottle. So, what constitutes a design? As I said, it's the appearance of a product. This could be the whole of the product, or it could be a certain part of the product. And what the appearance is could be one of a variety of things, or one or more of them. So it could be the lines, contours, colors, shapes, textures, the materials of the product, its ornamentation, surface decoration. And again, it's very wide-ranging in that graphic symbols are protectable by designs protection, as are typefaces, handicraft items, packaging. A key one to actually think about is, if you do anything with software, is that graphical user interfaces are protectable, as are, you can register animations, products in different configurations. An old-fashioned flip phone, for example, could be protected in its open and closed positions. You could protect different variants of a product. In particular, if you want to protect a wide range of different variants, there's some really good ways of filing them all in the same application to minimize your costs. So I'll now pass over to Greg, who's going to discuss more about the different types of design protection.
Thank you, Dave. So yeah, as Dave mentioned, the design right covers the shape and configuration of your product, and not the technical way it works, which would be ordinarily covered by a patent application. So I'm just going to go through the design rights that we advise on today. That's registered design in both the UK and Europe, an unregistered design right which exists in the UK, and also an unregistered community design right which exists in the European community. So registered designs, given by the virtue of its name, is an application that has been filed at an intellectual property office, which is then registered centrally on their database. A UK registered design provides protection in the UK only. The European community design provides protection in all of the European Union countries, which at the moment includes the UK during this transition phase. Design rights are also available in most jurisdictions in the world, and for the purposes of this webinar, I've just chosen the most important that might be for the viewers, which is Norway, Switzerland, the US and Canada. So the term of protection, once the design is published at the Intellectual Property Office, is 5 years from the filing date of the application to register the design. The design right is renewable for 5-year periods, and that takes you up to a total possible term of 25 years. So the costs of registered design rights, they're relatively cheap compared to patent applications, but of course they wouldn't cover the way in which your product works, only the shape and configuration of your product. So to apply in either the UK or the European Union, a design right can cost less than £1,000 per application. Once the application is filed at the intellectual property offices, there are no official searches or novelty examination. Basically, the intellectual property offices just check the formalities, make sure that the drawings are up to scratch and that they meet the requirements of the law. A design right in the UK and the EU typically takes about 3 weeks to be registered, so it's quite a quick process to have your design rights registered at the intellectual property offices. So there is a requirement for a design to be registered in that it must be new. That means that it's never been disclosed anywhere in the world before the application is filed. In both the UK and Europe, there is a grace period of 12 months from when the designer disclosed the design to be able to then register it at the intellectual property offices in both the UK and the EU. Of course, other countries and other jurisdictions may differ from the 12-month grace period that is afforded in the UK and Europe. Therefore, we strongly advise that if you have a design or are thinking of disclosing a design, to keep it secret until an application to register that design has been filed. So I'll move on to unregistered design rights and start off with the UK. Unregistered design rights apply to original designs that are not commonplace. Therefore, they need to have some sort of difference to the designs that have been available to the public. An unregistered design right covers the design of any aspect of the shape and configuration of whole or part of an article, and that includes internally or externally. An unregistered design right does not extend to pattern and ornament type designs such as surface decoration. As Dave mentioned earlier, unregistered design right is an automatic right that comes available to the designer when the design is made available to the public in the United Kingdom. So the term of protection in the UK for unregistered design rights is up to a 10-year period in which you can prevent others from copying your design. However, you must prove that there has been direct copying from the original design. I also say it's up to 10-year period because there are some niggly legal things that, whether it's from first sale or first disclosure, it can adjust the term of protection. There is also a further 5-year period available in which you can demand a royalty for use of your design, but again, you must prove that this has been directly copied from the original design. So moving on to the European community and the unregistered design right there. Again, this is an automatic right that becomes available to the designer when a design is made available to the public in the European community. And the unregistered design right is very similar to the UK in terms of protection, but the protection is only 3 years from when the design is first made available to the public in the European community. So I'll just move on to some future considerations which our clients are taking into account. Obviously, Brexit is affecting the design rights in the future. The UK left the European Union earlier this year, and we're currently in a transition phase. And that transition phase is due to end at 31st December 2020. So the crucial date is the 31st December 2020. Registered community designs that are published before the 31st of December 2020 will be duplicated onto the UK Designs Register at no extra cost to the applicant. So given that registered designs typically take about 3 weeks to register, we would strongly advise that if you want to get UK design protection from a registered community design, to have that filed in November. If you file an application in December and it doesn't publish but is currently pending, then you will have a 9-month period from the 31st of December 2020 in which you can file separately a UK design taking the date of the registered community design. But of course, if you're filing separately at the UK Intellectual Property Office, then you will need to pay the filing fees at the UK IPO. So after the 31st of December 2020, on the 1st of January 2021, if you want to protect your designs in both the European Union and the United Kingdom, you will need to file separate applications. We do know that unregistered design rights will be affected by Brexit, but at the moment during this transition period, and because the trade agreement hasn't been ironed out, we don't know entirely how these will be affected. So if you are preparing a product or thinking about filing design applications in the future, and you are interested in the United Kingdom, the EU, and other countries which are not taken into account in those jurisdictions, you could file an international application under the Hague Agreement, which could be a possible avenue for you to save costs in the future. The Hague International Application covers many countries and regions in one application. And again, I've listed a few countries here, which includes the EU, Switzerland, Norway, the UK, as well as the USA, Canada, and others worldwide. The advantages of the Hague system is because it's in one application and filed centrally, this reduces the costs of legal fees that you otherwise would have if you filed in each jurisdiction. The one thing to remember if you do want to go down the Hague system and the international application is that different countries apply different laws. Now, when the Hague System International Application is filed, each country examines the application as if it was filed in their own country. So you do need to take into account that some countries won't allow for multiple designs in one application or multiple depictions of the product itself. And the cost of the Hague System International Application, it really does depend on the number of countries and designs that you include in the one application. We generally advise to our clients that if they require 4 or more countries or regions, it's cheaper to file under the Hague system than in each jurisdiction. Okay, I'll pass back over to Dave to give you some examples of design rights.
Thank you very much, Greg. So I just wanted to give you some examples of registered designs that have actually gone to court. Now, as Greg mentioned, obtaining design right protection is relatively cheap in comparison to some other intellectual property rights. And from that, you may be thinking, well, I'm never going to want to run to the expense of taking a competitor to court over a design right. I'm just not going to be able to afford it. Now, the one thing to remember about design right protection or any other IP rights is that you can use it as a deterrent. You want to deter the competitor from going anywhere near, from infringing your design or stopping infringing your design long before you get to court. And that's certainly something that we could advise on if this ever became an issue. But these are just good examples, just because they did go to court. First one I'm going to talk about is the trunky case. So you've probably seen, if you look at the item on the left, you've probably seen the trunky cases in the old days when we used to go to airports, and this is a suitcase for children, which is also a sit-on case, which can then be dragged along with the child sat on the back. This was a great success story for a company called Magmatic, based down here in the southwest. And, you know, they sold a great number of these. A competitor, PMS International, came along and launched the Kiddie Case, which is the product on the right. It was specifically designed to compete on price and quality against chunky products. So you may argue that this was a guaranteed win for chunky. Unfortunately, this is actually a bad example if I'm trying to persuade you of the merits of obtaining registered design protection, as you'll see, Magmatic actually went all the way to the UK Supreme Court and lost. But I think there's some lessons to be learned as to why that happened, and, you know, ways that Magmatic could have been more successful. So Magmatic owned a registered design right, and the image in the middle shows an image from that registered design. This is a prime example of where, if they'd have got the design protection right at the start, they may have won this case. In my opinion, they'd have been much better showing what their design looked like in a different format, potentially with line drawings rather than shaded images, and taking away the different colorings. In fact, the judgment indicated something like that, and the judgment also indicated that, you know, in something like, with a case like this, maybe you'd have been better also having other forms of IP rights, such as patents. This next one I love, mainly because it's about chocolate. But in this case, Hotel Chocolate, which is had their chocolate slab, which they sell in a variety of forms, but they owned a registered design right for this irregular shaped slab. Waitrose came along and made their own version, which is shown on the right, and launched it. Now, you may think that there's little design protection in a slab of chocolate, but you'd be wrong. Hotel Chocolate immediately brought Waitrose's attention to their registered design that they held for the slab of chocolate, and Waitrose settled within a few days. They agreed to stop selling, and they very much came out with a statement which said that although they were confident they had not infringed any of Hotel Chocolate's designs, they obviously weren't that confident, though. They decided it wasn't in their interest to enter a protracted legal dispute, and decided not to restock the product. So just owning the right deterred a major company from going anywhere near this product. Interestingly, Hotel Chocolate turned it into a great marketing campaign and offered to replace anyone who had a Waitrose chocolate slab with their own version of the slab for free. Although why you'd have a chocolate bar for that long, I'm not sure. Anyway, moving on to a few key takeaways. So, firstly, design rights are a very good form of protection to use on their own, but also as part of an IP arsenal. It's very important that you choose the right form of IP to protect your product, or, you know, to use a multitude of different IP rights. Registered designs are relatively cheap to obtain and relatively straightforward to register. But equally, unregistered design rights exist automatically. And they're very good for deterring possible competitors. If you have different variants of a product, there are ways that we can protect those together in the same registered design application. And you really need to consider how to correctly illustrate your design. If you get that wrong at the outset, you can really limit the scope of protection that your registered design right provides. There are advantages to both registered and unregistered design rights. So, there's good reasons to have both. And it's easier to use a registered design right as a deterrent to a competitor. The one thing we've not really spoke about today is the value that design rights provide to a company or any form of IP. You can use design rights, registered designs to as a means to sell your design, to license your design, to obtain investment by showing value in your company by having these registered design rights. And I think that's it. So now's the time. If you've got any questions, we'd be quite happy to take those. Let me have a look and see if we have anything. So, first question. How can I mark my product to deter others from copying? Greg, do you want to answer that one?
Sure. Yeah, so when you have a product and you want to mark the product to make sure that it shows that it's unregistered design rights or registered design rights, you can mark the product unregistered design right reserved, followed by the name or company for unregistered design rights. For registered design rights, that's very similar to patent protection. On the product, you can put registered design number followed by the registration number of the design. Oh, there's another question here. In which countries should I apply for protection? Dave, do you want to take that one?
Sure. I mean, that's very dependent on a case-by-case basis. Typically, people, I've had people come to me and say, I want to get worldwide protection. Not a great idea. It would cost you a fortune. So really, you want to focus on the countries, your key territories. Where are you going to sell your product, and also where you're going to manufacture your product. If you're not going to sell it in a particular country, do you really need to obtain protection in that jurisdiction? Is the question I'd be asking anyway. What you want to do is minimize the cost. Another question. Can I file a registered design application with photographs of the product? Well, I'll take this one. Yes, I mean, perfectly possible for you to use any form of image when registering a design. However, as we touched on, it's really important that you choose the right form of image. If you take a photograph and submit that, then it can be very limiting because it shows all of the features of design, even ones that you don't particularly want to protect. Whereas if you change that for a computer generated image or a line drawing, then you can change the scope of protection. Everything with designs is based, the protection you've got all depends on what is shown in the image, in the images. And so you have to be very careful that you get that right from the outstart, from the get-go. The Trunky case is a prime example of that.
I think that answers, sorry, there's a question come in, can CAD files be considered a design? I think that's the same.
It's the same
as photographs, isn't it, really?
Yeah, you can file CAD files. Again, there's the format that you want to design, you file them in, and make sure that you're showing the correct features that you want to protect. Do we have any more questions, Greg? I can't see at the moment.
So yeah, when should I file a design registration?
Sure. So you should design, again, very subjective as to when you should file it. Obviously, as you're designing a product, you're going to go through various stages of development, and it's likely that the appearance is going to change. So you probably want to file it close to launch. Although, as Greg mentioned, there are sometimes ways that you can file it after you've publicly disclosed. I'd highly recommend that you file before you publicly disclose the product, because there are restrictions on where you can obtain protection if you don't try and obtain protection until after you've publicly disclosed. Okay, is there any more questions?
I think that's everything covered from there.
Right, well, I mean, if anyone does have any further questions, then our details are presented here on the screen. And I'm sure that there'll be links sent to you. So we can definitely handle any questions that you might want to send our way. And we've hoped that you've enjoyed this seminar. I'm now going to pass over to Michelle, who's going to provide some information regarding future webinars.
Yes, thanks very much. Thanks, Dave. Thanks, Greg, for presenting today, and thanks everyone for joining us. We do have a series of webinars planned for this summer. The next two in our Intro to IP series are an Intro to Trademarks, which is on the 30th of July, and an Intro to Freedom to Operate on the 20th of August. You can register for all our webinars on our website, and all our recordings of past webinars are also available there. They're available on the Inspired Thinking section of our website, but I will send a link through in the follow-up email to this webinar. We've also launched our podcast show, which is the IP podcast. It covers all aspects of IP in 15-minute jargon-free episodes. You can find this by searching for Danes on Spotify, iTunes, and Google Podcasts. That's it from us, but if you would like us to cover anything in an upcoming webinar, just drop us a line and we'll look into it. And I hope you'll join us for another webinar soon. Thanks, everyone.
Thank you. Bye.
Thanks.